Newzroom Afrika's Linda Mnisi has been following the Senzo Meyiwa trial and joins us now. I was going to say Senzo, so sorry, Linda. It seems every time we look at this court, we just want things to move forward and then it doesn't. And I was just looking at the socials just now on yet another postponement over something administrative or detail related. And the public's really getting fed up with this. One can only, again, always imagine what the family is going through in trying to get this, to someplace significant. So what happened today?
So today we were supposed to hear the further cross-examination of state witness and data analyst, Gideon Gouws. You'll remember his evidence has had to stand down because the defense said they didn't have certain information related to his testimony and that they needed to be furnished with those. So it happened about a week ago, if I'm not mistaken, and we're still at the same point where the defense says we were not furnished with what we asked for. The state says we did furnish them with Section 205. This is now the application that is made to access the data on the cell phones of the accused persons. And now we're at that point where they say they, in fact, want their entire batch in terms of the application that was made, for those Section 205. So everything that is administrative, everything that went into the Section 205, they want those before they can proceed. But also, you'll remember, accused number 4's lawyer said that there's certain information related to certain numbers that he needed, and he says he still has not received that, despite the state having said that they furnished him with all the documents in October. He said he did not have them. They gave him a different drive. He still could not access the information, and the information that he had, he says, still does not have the relevant information. So it's all administrative work, which then means the defense can't continue with its cross-examination. And until tomorrow, we can only wait until tomorrow to hear whether or not we will proceed on Wednesday, pending, of course, all the information that they wait for.
How did the judge take this? We didn't have our cameras live in court at that point.
Well, the judge wanted to know what is the position of all, the defense lawyers in terms of this evidence. And well, they seem to be on the same page to say, well, we can't say how long, because what he asked him was, how long do you need me to postpone for? For a day, for a year, for a month?
Was he really that sarcastic?
Because it wasn't clear at the time how long they needed. And they said they can only determine once they have all the information, and depending on the volume of information that they receive, because they still have to take instructions on the information that they receive. So they would have to look at it as lawyers first and then take instructions from the accused or their clients based on the information that has been made available. So at this point, the court says, well, we'll postpone until tomorrow. You'll consult. You'll have the entire day tomorrow to consult, and then we can then decide on when exactly the matter sits again for cross-examination.
So, but here's the thing. So we have been punting this as a day when it would be the bank statements. It would be, the central focus. It was going to be this cross-examination, which was going to be able to provide some really key, confirmation on where one of the accused, Sabia, was on the day of the murder. Why did the court, as we've seen before, then kind of just adjust its focus and maybe stay on that issue while the issue with Gideon Gouws, gets resolved?
It's been happening quite a lot with evidence recently, where witnesses would have to stand down pending, of course, the finalization of one element of that particular focus, and that, for example, the bank records. But if you look at Gideon Gouws' evidence, it sort of falls into the bank statements because it deals with cell phone numbers and the disputed cell phone numbers, and how those numbers, certain numbers, were used to open bank accounts. So if the state says we're able to link this number to accused number 5, for example, because he used it to open a bank account, and the bank account shows that on this particular day, this is where this person was. So it's sort of interlinked, and it's important that all of it, is weaved together. So that's why we've been seeing a lot of stops and goes with around the same particular evidence.
It's so interesting that after all this time, the public interest is so high in this case, and the desire for more details, more clarity and certainty to emerge in court. I've had people asking, on the socials, well, are you guys not taking it live? What's happening today? And as you say, time and time again, hamstrung by some of these evidentiary or administrative issues. Is it, again, it's anyone's guess, I suppose. It's an unfair question to you. Is it likely to go ahead tomorrow?
Well, tomorrow it's not likely to go ahead because obviously there are consultations that need to take place, and depending on the volume of information that they've required, I mean, they've asked not only for the Section 205s, but they want to know the process that was followed to obtain those Section 205s. So if there is, for example, anything that was flouted with the process of obtaining those Section 205, then they would want to challenge that. Not necessarily that you went to court, to a magistrate, you made an application for a Section 205, you were granted that, okay, everything must have been in order. They want to look at the process that was followed in order, of course, to challenge the evidence in its entirety. So depending on what they receive tomorrow and depending on the information that, for example, accused number 4 will receive on the cell phone numbers that he's looking into, then we will then get to hear whether cross-examination will continue on Wednesday or Thursday, or it will have to stand down till the following week. But in as far as tomorrow is concerned, the judge clearly stated that they would have to come to court for consultation, because it becomes a bit difficult to consult, as the defense has previously said. It becomes a bit difficult to consult in prison because of a lot of the rules that they have. So it's better that the accused persons are brought to court and they use the court's time to consult from 10 o'clock right up until 3:30.
Well, it's very interesting because at the very least what we're getting, Linda Mnisi, is a legal education on various aspects of the law, the Criminal Procedure Act in particular. So that's one benefit, I guess. All right, we'll keep tabs on this one, Linda Mnisi. Thank you very much.